Okay, good afternoon, everybody. Today we're here to talk about Brexit and the data protection implications of that particular evolution in our relationship between Ireland, the United Kingdom, and the European Union. This is a topic that I've spoken on extensively over the past couple of years. Indeed, the week after the referendum, myself and Tim Turner from 2040 Training in the UK did a webinar on the implications of Brexit and on data protection and the implications of data protection on Brexit, where we mapped out 4 potential futures, and we are now currently sitting in one of those. So that webinar is still available on YouTube if anyone wants to go and look at it. And again, you can see how the evolution of the situation has been less than rapid over the past 3.5 years. And we are now sitting in a situation where many of the things that Tim and I were concerned about back in 2016 remain to be fully addressed. So the objective of today's webinar is to go through those issues, both from the point of view of EU organisations dealing with the UK, but also from the point of view of UK organisations interacting with the EU as well. Although the primary emphasis will be on EU to UK, particularly for Irish organisations. As I said, if you have questions, please jump in with the questions using the Q&A function, and I will see them popping up here on the screen in front of me. So the agenda for today is, very quickly, a review of where we are now. We're going to then look at UK or EU to UK data transfers and what's going to happen next. We're going to look at UK to EU data transfers and what happens next. We're going to touch a little bit on the implications for competent authorities in the law enforcement context. And then we're going to cut to the chase and look at what sort of next steps your organizations should be thinking of in terms of practical things you can be doing to prepare and mitigate risk. Because ultimately, from a data protection perspective, a lot of this is around identifying what risks might arise and having plans in place to address and mitigate those risks. So, where are we now? It is now the 3rd of February. The good news is we have the beginnings of some certainty about the situation in terms of we can now start saying some definitive things. But before we start saying some definitive things, this is the slide that I was using back in 2016 to summarize Brexit immediately after the referendum. Immediately after the referendum, what we knew was that the United Kingdom was leaving the airplane. The open question we had was whether they were wearing a parachute or not, and whether or not the ground would negotiate a soft landing with them. Things have moved on slightly since then. Just to summarize where we are now since the beginning of the process. Back in 2016, we had the vote for the referendum. We had the vote that the United Kingdom would leave the European Union. In March 2017, Article 50 was triggered with no consideration as to what the future relationships might look like. We then went into 2 years of negotiations on a withdrawal agreement. In October 2019, a withdrawal agreement was published, which was basically a minor reworking of the agreement that had been in existence the year previously. And on January 24th of this year, the withdrawal agreement has been signed by both the United Kingdom and the European Union and is now in effect and in force as a treaty. And as of the 31st of January 2020, the United Kingdom has left the European Union. There is no return. The Article 50 process has now concluded. The position we're in now is that we are in a transition period. We are in a transition period that ends by operation of law on the 31st of December 2020. And at the end of that transition period, whatever is in place in terms of future trading arrangements, adequacy decisions, etc., will be what is in place governing the relationship between the European Union and the United Kingdom thenceforward. Within that construct, within the confines of that, the European Union has made a number of undertakings in the political declaration that is associated with the withdrawal agreement around beginning the process for things like the adequacy decision in a timely manner, with a view to concluding an adequacy decision assessment by the 31st of December 2020. But again, that's couched in a number of caveats, which we'll talk about later on. The key point for those of us who are looking at the data protection issues and risks in organizations is that prior to October, we were facing a number of hard Brexit windows. We had a hard Brexit nominally at the end of March of 2019, but again, there was an extension negotiated, and we were facing a hard Brexit if there hadn't been an agreement on the withdrawal agreement in October. We were facing a hard no-deal Brexit. We're now in a similar position because up until June of this year, it will be possible for that transition period to be extended by unanimous vote by the European Parliament, the European Commission, and at the request of the United Kingdom. That's allowed for in the withdrawal agreement. However, that has to be requested. And we're back to another cycle of brinkmanship to an extent, where we now have an 11-month window during which data controllers in both the UK and in the European Union need to start putting in place their plans for what they're going to do at the end of this transition period. And that's what we're going to talk about today, what those plans might need to consider. So to summarize, the current status of where we're at can be presented with a reworking of a slide from 2016. We are now at 2,500 feet. We're still not sure whether the parachute contains a parachute or last week's dirty laundry, but we do know that the United Kingdom has definitely left the aircraft. And by operation of time, physics, and law, on the 31st of December, unless there has been some other intervening act that triggers an extension to the transition period, or unless a number of significant things are delivered in terms of future trading arrangements, agreements and standards, agreements on alignment between the legal and regulatory structures in the UK and the European Union, and the agreement of an adequacy decision for data exchange, then we have a lot of uncertainty that needs to be mitigated during this period. And in that uncertainty, we need to be clear what are the risks, what are the issues, and what can we do about them. So what has changed since last week? Last week, the United Kingdom was still in the European Union. What's different now? Well, the key difference is the UK is now a third country. The operation of data protection law, as we knew it last week, in this transition phase, is governed by the withdrawal agreement, which is a treaty. And that withdrawal agreement allows for the status quo to continue until the 31st of December 2020. As I've already said, this just defers the risk of a no-deal Brexit, because prior to the withdrawal agreement being finalised, we were looking at no deal on how they would leave, how the UK would leave. Now we're facing the potential of no deal in terms of how we will continue to operate. So the transition agreement, the withdrawal agreement, provides a transition period during which nothing substantively will be changing. However, the ICO is no longer a full member of the European Data Protection Board. It won't have any voting rights. It won't have any decision-making powers in an EU context. And one of the key changes for anyone who is involved in binding corporate rules, for example, is that the ICO will cease to be a competent authority for the purposes of deciding or being the lead supervisory authority in relation to binding corporate rules. So there was a flurry of BCRs announced just before Christmas from the ICO, and I think that's nice. but in the next 11 months, unless there is some change to treaty and legislation to allow the ICO to be a supervisory authority competent to operate binding corporate rules under EU law, all of the binding corporate rules that exist that are currently using the United Kingdom as their lead supervisory authority will need to relocate. The GDPR, and by extension, the parts of the law enforcement directive that have been transposed into UK law, continue to be retained in UK law under the withdrawal agreement. The UK Data Protection Act has, as of the withdrawal day, the exit day, which was the 31st of January, been amended. And what we now have, if you look at the UK's Data Protection Act, there is reference to this beast called the UK GDPR, which is their localized version and their amended version of the GDPR that removes references to EU institutions and replaces them with references to UK institutions. Essentially, it was a Control F in the text of GDPR, looking for anything that relates to the European Union and replacing it with a similar construct in UK law. Now, when we get into the nitty-gritty of that and the technicalities of that, there are some interesting questions about whether that process may have actually weakened the adequacy and alignment between the UK's Data Protection Act and the requirements under EU law. But that's a question for the legal scholars to debate over. One of the key aspects of this is that in the UK, all of the adequacy decisions that the European Union has decided on, the European Commission has decided on historically, are carried over as a transitional arrangement. But again, key word in that sentence is transitional. This is not a permanent state of affairs, because the UK's legislation can evolve, will evolve, and almost certainly will diverge in various contexts, particularly when we start looking at how the trade in data and the use of data in commerce is a key factor in international trading agreements in the modern age. Standard contractual clauses are now recognised in UK law, and the ICO has now been given the power to issue their own versions. So again, we immediately begin to see the potential scope for divergence between UK and EU, is the European Commission defines the text of standard contractual clauses for the European Union, which gives them legal effect. In the UK, they decided that the ICO will do that. The regulator, in effect, is being asked to define the contractual terms which they will then be required to enforce. This raises some issues, potentially, around separation of powers, separation of duties, and the ability of the ICO to hold people to account for breaching contractual terms, or in relation to contractual terms that are not compatible with EU law that the ICO may have been involved in drafting. One of the key changes we see in the UK Data Protection Act, because they have their control-find approach to replacing GDPR references in the UK Act, is that they now require the appointment of nominated representatives in the UK in certain circumstances. So if you're an EU business engaging in non-occasional processing of personal data of people living in the United Kingdom, you will require a nominated representative in the United Kingdom. Again, this is something we've dealt with for a number of clients in the past couple of years, and it is interesting trying to get the understanding across of what that means in practice. The European Data Protection Board's guidance on the role of the nominated representative is interesting in this context, which guidance which came out towards the tail end of last year, which we'll discuss a little bit later on. So in terms of the legislative environment we're looking at, the jigsaw we need to consider, we have four main blocks that we need to be considering. We need to be considering the underlying EU law, the regulation and the directive. So the regulation, GDPR, and the law enforcement directive. We also have, for those of us who are data controllers or data processors operating in the Republic of Ireland, the Irish Data Protection Act 2018, and we have the Data Protection Act 2018 in the UK, and the amendments to that act that were brought in with the catchily named Data Protection, Privacy and Electronic Communications Amendments, etc., EU Exit Regulations 2019. So good, they named it twice. So there are four key areas we need to look at in terms of the operation and interoperability of our controls and our governance framework going forward. I cannot understate the significance of Brexit from a data flows perspective. It's worth bearing in mind that the regulatory framework and legislative framework and technical capabilities around data exchange that we live with on a daily basis did not exist in many circumstances when we prior to Ireland and the United Kingdom joining the European Union in 1973. Our commercial models, our engagement and exchange of data habitually with organizations in the UK has grown up in an environment where there was a relatively benign regulatory framework that was structured for the purposes of allowing and permitting the transfer of data between the member states, and also put in place some structures governing the transfer of data across borders in other contexts. But as we walk down the high street in a small country town like Wexford, and we see UK chain stores on the main street, it's worth bearing in mind that their ability to operate and share data back to a UK head office is in many cases something that has grown up in an environment where there were no impediments to doing that. What we now have is a regulatory environment emerging that will put in place some impediments, some barriers, some restrictions around the exercise of those data transfers, and organizations need to make themselves aware of what those issues are so that the appropriate controls can be put in place to minimize the impact of Brexit from the 31st of December 2020. When we look at our legislative framework, the key challenge we have is that the United Kingdom has now become a third country. It is not in the EU, it is not in the EEA. It has left. It might become part of the EEA in the future, if that is the nature of the agreement that is reached by the 31st of December 2020. It is not within the scope of EU data protection law. It is not within the European Union. It is outside the territorial scope of legislation. And because of this, we now require distinct basis for transfers. At the moment, the basis for transfer is the withdrawal agreement, which has an undertaking in it to allow business as usual to continue until the 31st of December. But there are some problems looming in the future. And I use the images of car crashes, air crashes, and train wrecks advisedly, because we have a number of speed bumps we potentially will hit as we evolve through the discussions between now and the end of December. The first issue we have is that the UK's Investigative Powers Act has been ruled by the European Court of Justice to be incompatible with EU law in the way it is implemented. Interestingly, the UK High Court has affirmed that decision. Therefore, the UK's own judiciary say this legislation needs to be amended. The European Court of Justice has indicated why it needs to be amended. And that is a point that will go to the discussion of adequacy. And it's a point that will go to the discussion of either adequacy defined by the European Commission or self-assessed adequacy by a controller in certain circumstances. The UK's Digital Economy Act also raises some issues that might lead to incompatibility with EU law, not least because it envisages quite a broad range and scope of data sharing on the basis of a very broad statutory basis, not dissimilar to the Data Sharing and Governance Act here, which has not yet been fully enacted because of concerns around the compatibility with EU law. Another key issue that we will need to be paying attention to both over the next 11 months and going forward is the use of secondary legislation to repeal EU law or to repeal UK law. These so-called Henry VIII powers that the UK Parliament is proposing to use to make amendments. And again, we've seen it happening already with the amendment to the Data Protection Act 2018 in the UK, where they've introduced regulations that make very significant amendments to the Act that were not subject to parliamentary scrutiny. This is a thing that will continue to happen. And again, the Irish experience here is interesting because we're the only Western European country to have voluntarily left a political and socio-economic union in the 20th century. And in the Irish government, there are still functions. There is a function in the Irish government whose job it is to repeal old legislation. And one of the interesting nuggets of Irish legislative evolution is that until 2015, it was technically illegal in the Republic of Ireland to criticise the second marriage of Henry VIII, because we hadn't repealed that particular Henry VIII clause. It's also important to bear in mind that the UK's Data Protection Act itself is subject to challenge at the moment in the UK, potential for referral to the European Court of Justice, because it carves out an exemption for personal data of people who are going through an immigration process. They are denied their fundamental rights. Now, is this necessary? Is this proportionate? That's a substantial and open question. And this is just one of the provisions that could result in a finding of incompatibility between the UK's data protection regime and the EU's requirements post-Brexit. And all of these may give rise to concerns around adequacy. So, if we're in the EU and we're sending data to the UK, what are our choices? Well, the Data Protection Commission has been very clear on this since day one. Model clauses are the go-to move, standard contractual clauses. They're there, they're structured, they provide a basis for a structured approach for data transfer between an EU member state and a third country where there is no other mechanism in place at this time. Binding corporate rules is also an option, but one thing that still seems to confuse people is that binding corporate rules only applies in terms of an internal or intra-company transfer of data. So if you are sharing data with a subsidiary company as part of a holding group, yes, binding corporate rules will work for you. That's what Intel have done with their binding corporate rules that they have with the ICO. But if you are working with a third-party service provider who's providing technology services to you or doing data processing on your behalf, you can't use binding corporate rules with them because they are not part of your company. They're not part of your organization structure. Binding corporate rules ultimately is a codification of internal policies, procedures, and standards mapped to the data protection laws of a member state of the European Union, which are then approved by that member state data protection authority. And that approval is then recognized by the other member states at the European Data Protection Board level. Failing model clauses, binding corporate rules, adequacy is our ideal happy place to go to. This is where there is an assessment by the European Commission of the data protection standards that exist in a legislative context and in a judicial oversight or administrative law context to ensure that the fundamental rights and freedoms of individuals can be given effect in the receiving member state, or sorry, the receiving jurisdiction when data is being transferred out of the European Union. And the presumption has been that this will be a foregone conclusion for the United Kingdom. The presumption on the part of the United Kingdom has been this will be a foregone conclusion. However, all adequacy decisions have to be taken on merit, and it has to go through a formal scrutiny and decision-making process in the European Commission. There are no shortcuts. Japan, for example, has amended its data protection laws on a number of occasions over the past couple of years. as part of its journey to achieving data protection adequacy with the European Union, as part of its overall trading agreement with the European Union. And that process took over 7 years. So anyone who thinks that in the next 11 months, there will be some form of fast-tracked adequacy decision from the European Commission, I admire their optimism. But adequacy takes a long time when it's being done properly, and it is usually tied up with alignment of regulatory standards, alignment of domestic legislation, and a number of other factors. The United Kingdom arguably has a head start, but we cannot assume that the duration and the time taken to achieve an adequacy decision will be in any way faster. Finally, in terms of structured ways of transferring data, as I call them, there's this requirement around contractual necessity. So is it necessary for the execution of a contract entered into by the data subject or on their behalf? And this is where you need to be really, really careful, because if you're looking at that from a contractual perspective, is it necessary? Which means you need to have looked at all the other ways in which you could have done this thing, which would include, are there any other suppliers? Is there another way of doing this that doesn't require the transfer of data outside of the European Union or the European Economic Area? So if you're going to fall back in contractual necessity, you need to be really, really clear why and how that is necessary for the execution of the contract that the individual has entered into. For example, if you were doing online ordering, online retail, and the fulfillment and pack and pick is taking place out of a warehouse in Manchester, well, arguably it is necessary for that contract, for the execution of the contract, to get those goods to that customer, for their data to be transferred to the United Kingdom. But that will be much more reliably done on the basis of a model clauses basis between you and the third party providing the pack and pick capability, or ideally on the basis of some form of adequacy decision. So ultimately, model clauses are a good bet. Binding corporate rules are a reasonable bet within a corporate structure. Adequacy is where we'd like to get to, but it's not going to happen in the short term. And contractual necessity is something you can point to, but only if you've really done your homework as to whether it is actually necessary for that contract. When we look at model clauses, there are two main categories: controller to controller and controller to processor. At this time, there are no processor to processor clauses approved by the European Commission. So if you're involved in a chain of processors, and you, for example, are working with a third party in Paris, and that third party in Paris is in turn using a third party based in the United Kingdom, there is no processor to processor agreement you can put in place. So you would need to consider contracting directly with the UK processor for whatever service they are providing. So understanding your chain of processors becomes really, really important when you start looking at model clauses, because you mightn't necessarily be aware from your initial list of suppliers, your initial list of parties who you are sharing data with or transferring data to, that data is winding up in the United Kingdom. So in terms of your controller to controller clauses and your controller to processor clauses, due diligence is required on the end-to-end transfer so that you can identify that you've actually got all the right agreements in place. Similar to the title deeds in a house. If you have a gap in title deeds, if there's a break in the title on property, that can become problematic if you're trying to sell your house. Likewise, if there's a break in the chain of contractual basis for the processing or for the transfer of data to the United Kingdom, this can become problematic as well. Again, this is where model clauses, while they're a quick band-aid solution, bring with them additional complications that organizations need to be aware of. It's also important to bear in mind that in the controller, in the model clauses themselves, there is some language that may become problematic when we consider things like the Investigative Powers Act in the United Kingdom. I'll bring this up here and show you. In the controller to controller clauses, when we look at the obligations of the data importer, the data importer is warranting, amongst other things, that there is no reason to believe at the time of entering into the clauses that there is any local law that will have a substantial adverse effect on the guarantees provided for under these clauses. So in the context of your processing activity, in the context of what sort of data sharing is happening, what processing activity is taking place, or what categories of data are being shared, the importing party, the importing controller, again, this is essentially a joint controller relationship, bear in mind, so there may be liability to consider here. If there is any reason to believe, so this is a positive assertion that they have no reason to believe at the time of entering into clauses that there's any local laws that would have substantial adverse effect, which means if you're receiving controller, if the data importer has any awareness or any reason to believe that there are any local laws that would have a substantial adverse effect on the guarantees, this clause becomes inoperable. It becomes difficult to execute your model clauses in this context because they had controls and safeguards built into them to protect the fundamental rights and freedoms of data subjects. Likewise, when we look at the controller to processor relationship, we see similar language in clause 5b of the controller to processor clauses. The importer agrees and warrants that they have no reason to believe that the legislation applicable to it prevents it from fulfilling the instructions received from the exporter. So the challenge here is if, for example, the United Kingdom was to decide to outlaw encryption, this would create an impediment in the future to the operation of model clauses as a basis for transfer. Immediately, there is something in existence in the domestic legislation in the United Kingdom which would pose a problem. And again, the Investigative Powers Act has a number of provisions within it that could impact on the ability of processors to fulfill obligations to data controllers, or could undermine the guarantees or have an effect on the guarantees provided for in the model clauses from a controller to controller perspective. And this is why the use of secondary legislation in the United Kingdom to amend EU legislation or to introduce new legislation as part of the withdrawal process is potentially problematic for the reliance on standard contractual clauses. And this is before we even get into the nitty-gritty reality of the fact that standard contractual clauses are subject to a court action in the European Court of Justice at the moment in the Schrems II case. So the risk we have from Schrems II is that there are some very specific questions being asked around the basis for assessing the validity of standard contractual clauses. And if you want to find out the breakdown of those questions that were put forward from the Irish High Court, there's a blog post on the Castlebridge website. I'll send around the link to that in a follow-up email to this webinar. That'll give you a list of those questions. The Advocate General's opinion that came out just before Christmas was very much of the view that supervisory authorities have the power to suspend standard contractual clauses for transfers of data, and that they should exercise that power. There is a high risk in that context of standard contractual clauses being suspended to and from different jurisdictions. And while the focus is on standard contractual clauses for transfers to the US, I think we should be more concerned about the fact that we need to be putting something in place now for transfers to the UK, and there is a question mark over whether or not there will be long-term robustness in the use of model clauses. So for transfers into the UK, the risks really come from the Investigative Powers Act, the alignment of the Data Protection Act with EU standards, and also the alignment of the ICO's independence in this construct and alignment of the UK's Data Protection Act 2018 as amended, particularly as the ICO and the United Kingdom have now left the European Union, which means they are not bound by the Article 8 and Article 16 obligations, the Article 8 of the Charter and Article 16 of the Treaty, both of which require independent regulatory authorities. So at this point, the scaffolding that underpinned the independence of the ICO isn't there anymore, and they are now a creature of the UK Parliament. And as such, there's an open question as to how independent would they be in future, or would constraints be placed on their independence in future through secondary legislation. And it's worth bearing in mind that if you're an EU-based controller, you are still carrying the risk of illegality of transfer. So if you're sending data to the UK and there isn't a basis for that transfer, you as a controller are in breach. And it's up to you to make sure you got the correct frameworks in place to underpin that transfer. So we mentioned binding corporate rules earlier on as a ground for transfer. It's important to bear in mind that they're internal standards. They are not applicable outside of the scope of your organization. So that's something to bear in mind if you are looking at them. Also, the waiting list to get them approved is quite long. I know the European Data Protection Board is looking at mechanisms to speed up the process for approval of binding corporate rules. But Schrems 2 raises its head here again because there were specific questions raised around the decision-making around binding corporate rules as well in that case. And it'll be interesting to see how the court deals with those questions, because that will inform how the EDPB and supervisory authorities in the remaining EU member states will deal with binding corporate rules decisions going forward. So adequacy. This is the one we want to be able to get to, some level of adequacy on the framework of data exchange between the United Kingdom and the rest of the European Union, because this is the one that most closely allows us to continue as we have always been. In the political declaration, it is recognized that high standards of data protection to facilitate data flows are essential. The European Union has committed to commencing as soon as possible after withdrawal the process of evaluating the adequacy of the United Kingdom, with a target of reaching a decision by the end of December. Now, there's a lot there to unpack. First of all, the United Kingdom has to request adequacy. They haven't started that yet. Secondly, it's a target. The European Commission, as we know from the negotiations and discussions on GDPR and the Law Enforcement Directive and the tortuous discussions around the Privacy Directive, are renowned for not quite meeting deadlines sometimes. And given the amount that needs to be done between now and the end of December, the target of reaching a decision is at best a stretch goal, particularly when we consider that the political declaration explicitly recognizes that applicable conditions have to be met. And those applicable conditions will include things like alignment with the European Charter of Fundamental Rights, alignment with the European Court of Justice, some mechanism for reflecting and producing meaningful equivalence in the oversight and governance of data protection obligations in the United Kingdom. And referring back to the Schrems 1 case and the need for meaningful equivalence to be in place. The other aspect of those applicable conditions will also include things like regulatory oversight and judicial oversight of the Investigative Powers Act. And has the UK actually dealt with the issues that have been identified in that legislation where there is an incompatibility with EU law? While the UK was in the EU, we would discuss and debate and push back and forth about those things. But now they are outside the EU, this creates a problem in terms of it reaching an adequacy decision. Ultimately, the political declaration is at best aspirational and not affirmative. And what I mean by that is it's a hope. The reason we have the political declarations in EU treaties is it's where we capture the assurances that we're going to try and move things forward in the next phase of this particular process. The fact that this isn't bolted into the actual withdrawal agreement itself and there is no firm undertakings is a key issue in that context. From the point of view of the Law Enforcement Directive and the adequacy of transfers under the Law Enforcement Directive will need to be underpinned by commitments to fundamental rights, according to the European Commission, the European Union's briefing papers on the next phase of negotiation. And specifically, they're looking there at the role of the European Court of Human Rights and the role of the European Court of Justice in meeting those commitments. And bear in mind, the rhetoric we have had over the past couple of years in the United Kingdom around the role of the European Court of Human Rights, the European Charter of Human Rights, and the role of the European Court of Justice. This will become politically problematic in the United Kingdom, I would suspect. One of the key elements of this, though, is the political declaration is very clear that the prerequisites for cooperation and the prerequisites for moving forward to an adequacy decision are the fundamental human rights basis of data protection law and the establishment of adequate frameworks around the protection of personal data. And while the ICO's existence, while the legislative frameworks that exist are useful in establishing the beginnings of that, there are still gaps, as I've identified earlier. Other caveats. The European Commission reviews adequacy every 4 years. It's never a certainty. Canada is currently looking at updating its privacy laws to ensure that it is aligning with the evolved adequacy requirements post-GDPR. And South Korea is currently in negotiations to get adequacy, and they've been at that since at least 2015. Japan took 7 years. South Korea is currently 5 years into a process as part of trade negotiations. And the UK is not being put to the top of the queue in trade negotiations. So some of the problems we see lying ahead. UK's mass surveillance has been ruled unlawful in the European Court of Human Rights. And the UK Court of Appeal has ruled that the Investigative Powers Act is inconsistent with European Union law. So that was the precursor to the Investigative Powers Act, that was DRIPA. But the underlying issues that have arisen in that context speak to the, and still apply in the context of the Investigative Powers Act, which is actually much broader scope. And they hadn't addressed any of the underlying issues in the legislation in that context in terms of its compatibility with EU law. Over the weekend, news broke that the Japanese Personal Information Commission has rolled over mutual adequacy for the EU and extended it to include the UK. However, when you look at the detail of that, it is only rolled over in the context of the transition period. And the Japanese are looking to see what the European Union will do in relation to the UK's adequacy, and that will still have a potential impact in the Japanese context. Also, there was some discussion around whether you could then use transfers from the EU to Japan and onwards to the UK to get around adequacy issues. Unfortunately, it would appear that's not the case, because there still needs, under Japanese law, there would still need to be assent from the transferring member state for the onward transfer into the UK. So it will get complicated as people try to find clever ways around things. When we look at the unstructured methods for transfer, so they're the structured methods. Unstructured methods, we're looking at if it's required by law, if it's explicit consent of data subject, and including a statement of the risk of inadequate protections, if it's necessary for the conclusion of a contract with or in the interest of data subject, if there's substantial public interest in the transfer, if it's necessary for obtaining legal advice, if it's necessary to protect the vital interests of the data subject, or if the data is listed in the statutory public register. These are all grounds we can point to for data transfers outside the European Union. One of the key challenges we're going to have is that the European Data Protection Board's guidance from last May, from May 2018, on unstructured data transfer methods highlights the fact that these cannot be things that are happening regularly or occur outside the regular course of actions at random or unknown circumstances and with arbitrary time intervals. So if it's an ongoing systemic transfer of data, it is unlikely you'd be able to rely on those unstructured grounds on an ongoing basis. So Again, going back to the idea of being able to use contract as a basis, necessity within the terms of a contract. Yes, if it's an occasional thing, but if it's an ongoing exchange of data between two organizations where that data is moving, you probably won't be able to rely on contract, which means you're back to model clauses or back to adequacy. And they explicitly called out in the EDP guidance data transfers that occur regularly within the context of a stable relationship. That's ultimately a systemic and repeatable transfer. So in that context, we need to be very clear that those unstructured things are should be considered emergency basis, not necessarily the basis for ongoing transfers. Transfers under court orders, again, allowable. We're not going to have the wheels of justice grinding to a halt, but there needs to be some form of international agreement, such as an MLAT, under Article 48 of GDPR, particularly when we're dealing with investigation, detection, and prosecution of criminal offences. And decisions from third country authorities are not in and of themselves grounds for data transfer. We need to have something else there, which brings us back to the importance of the transition period. Currently, we have an agreement in place that is allowing these transfers. After the 31st of December, it's an open question what form of agreement we will have in place to allow these transfers. And MLATs take time to negotiate. The UK is leaving a very tightly bound up set of mutual obligations and arrangements, and it will take time to put those back together. And this is one of the key challenges we see going forward, particularly in relation to those sorts of occasional transfers, like court order transfers on the basis of a court order. For competent authorities in the context of law enforcement, a couple of key issues you need to be aware of. And these are largely the same as the issues that organizations outside of law enforcement context need to consider as well. What's the international agreement or legally binding arrangement underpinning the transfer? Is there an MLAT in place? Is there some structure in place allowing this transfer? Again, until the 31st of December, we can be pointing to the transition agreement, the transition period under the withdrawal agreement, but after that, who knows? Which means we're then looking at other grounds for transfer under the Law Enforcement Directive, which include threats to public safety or protection of the vital interests of data subjects or another. Those require a necessity test, and those are a case-by-case decision, and also they are not the basis for ongoing systemic exchange of data. And that's a key challenge. And also, one of the other challenges that needs to be considered when we're dealing with the UK from a law enforcement context, once they're out of the core structures of EU law, is what are the controls we're going to be putting in place against onward transfer of data to other law enforcement agencies within the UK or outside the UK for other purposes. And again, this is another challenge under the Investigative Powers Act in the UK. Another problem we have for law enforcement perspective is the UK has not exactly covered itself in glory in the last few months in terms of its attitude to the data it was given access to. Firstly, they were caught taking illegal copies of the Schengen databases. These are the databases of movement between EU member states under the Schengen Agreement. They took copies of it illegally. Doesn't exactly bode well for the basis of trust that needs to exist for the purposes of agreeing an adequacy basis. Also, they forgot or declined or decided not to update EU databases in relation to 75,000 criminal convictions. This is where they were required to transfer data to the EU home countries of individuals who were convicted. But that didn't happen. And rather than say, oops, we made a mistake, they decided to cover it up. Again, all of these things raise questions about the UK's future adequacy decision. So that's from the EU perspective. Very quickly, we're going to look at the UK perspective. What does it mean? Well, what the UK Data Protection Act says about Brexit in its amended form is that, well, it creates an entity known as the UK GDPR and also an entity known as the applied GDPR at a point, which is a transposition at a point in time of the GDPR into UK law. As I said earlier, it's basically Control F in the UK Data Protection Act to replace any reference to EU GDPR, to the GDPR, with a reference to the UK GDPR, but we now have a specific reference to the EU GDPR in the UK Data Protection Act. We have the UK GDPR, and we have this entity called the applied GDPR as well. It's a mess. If we have no agreement on the future relationship, the UK GDPR, UK Data Protection Act will not be underpinned by EU principles. It will sit outside the EU structure. So we don't know what the underpinning of it's going to be. It will be resting, as it stands at the moment, on the unwritten constitution of the United Kingdom. And that has worked out very well during the Brexit process, not having a written constitution. And there is also a risk that it will be outside the scope of Court of Justice rulings. It will be outside the scope of Court of Justice rulings. How persuasive those rulings might be on the UK judiciary remain to be seen. The other aspect of the amended UK Data Protection Act is it is removing that fundamental grounding in the EU treaties and in the Charter of Fundamental Rights. So the Charter of Fundamental Rights is not being transposed into domestic UK law now. And based on my analysis, my reading of the way the Data Protection Act is framed, and the potential removal of things like the Human Rights Act and the exiting from the fundamental rights structures within the treaty, the EU treaties and the EU Charter of Fundamental Rights, there is no fundamental right to data protection currently in UK domestic law, other than that which they have inherited and carried forward through the transition period because they have been members of the European Union. One of the key issues for non-UK based controllers is that we will be required to nominate representatives if we're engaged in non-occasional processing of data of UK residents. This is similar to the nominated representative provision that exists in GDPR, but again, this isn't something we've had to do before. So identifying a nominated representative, engaging them, setting them up to be the liaison with the ICO for those customers or those staff or those data subjects whose information you're processing in the UK becomes an issue. One of the other risks we can identify is that any provision of the UK GDPR can be modified by statutory instrument. It doesn't require parliamentary oversight to the same extent as primary legislation. This means there is a significant risk of divergence over the next while, albeit a natural part of the process. But during the transition period, we don't know what's going to happen. The post-transition period, the UK's data protection law can be modified by secondary legislation. And as I've already said earlier, there's a High Court ruling in the UK regarding exclusion of immigration processes from the application of the UK Data Protection Act is the beginnings of that divergence. They've decided that they've ruled that immigration processes do not fall within the scope of the Act, and therefore there's a class of data subjects who are excluded. That is the beginning of divergence in the UK legal framework. So much and all as we've seen divergence in other areas, we will see over the next couple of years, I suspect, quite a degree of divergence, unless the final future agreement includes that divergence built, includes convergence or regulatory alignment. And that has been one of the key points of discussion before Christmas, was the maintenance of some form of regulatory alignment. But one of the challenges in that is we are now hearing from the UK since the exit day that there will be no alignment with the EU on regulation, there will be no alignment with the European Court of Justice, there will be no alignment and no concessions from the UK on these principles. So it's going to be bumpy. The binding corporate rules risk in all of this is that any organization that has binding corporate rules approved through the United Kingdom, well, on the third, they're no longer a supervisory authority. The ICO ceased to be a supervisory authority, and by the 31st of December, you will probably need to have changed your country of prime of lead supervisory authority registration and get your binding corporate rules reapproved. So again, it's worth considering that implication as well. The nominated representative aspect of the UK GDPR replicates the regulation, but unlike the European Data Protection Board, we do not have any guidance yet from the ICO as to what the nominated representative role will be expected to perform in the UK. Now, we can assume they will do a relative, they will map reasonably closely. Nominated representatives won't be able to be the DPO. They will need to facilitate a liaison between the data subject and the controller. They'll need to maintain the ROPA for the purposes of those activities that are taking place in the UK, and they will need to liaise with the supervisory authority and cooperate with the supervisory authority on behalf of the controller. The EDBP guidance is also indicating that there is less concern around liability for a nominated representative, but again, we don't know yet how well that will translate into the UK's interpretation of and application of this role. So it's an interesting one to watch going forward. Other future risks we need to think about. We've got the model clauses challenge in the European Court of Justice. There's a risk that clauses could be struck down by a supervisory authority or by the Commission or by the Court of Justice. And again, this is all going to come to a head during the transition period. There's also a risk of activist action against the EU in relation to transfers to the UK. So all it will take is for an organisation to launch a challenge to the use of model clauses, and we may find further uncertainty around the use of model clauses or binding corporate rules in relation to the UK. UK organisations, which are our experience, are unprepared and unaware of issues. We've been dealing with this for a number of years on behalf of clients in Ireland who have UK-based partners, subsidiaries, or sister or parent companies, and we still find a degree of reticence in terms of understanding and accepting the worst case scenario that needs to be planned for. This can lead to delay in getting things put in place, like model clauses or other agreements or other contractual provisions that might need to be put in place. So the earlier you start this process, the better you will be able to identify the changes that are required. Ultimately, planning for Brexit comes down to three things: assessing your exposure, identifying and defining your basis for transfer, and implementing remediation. Having a plan is key to all of this. Your register of processing activities is your best friend here if it has been compiled correctly, whether you're in the UK or in an EU-based controller. Looking at who your third parties are who are handling data or interacting with data, be they suppliers, partners, joint controllers. Identifying where they are based, looking at the chain of processors who might be sitting behind that, and understanding what are the processing activities that are likely to be affected and putting in place appropriate mitigations around them. Quick win approaches: get your model clauses in place. Look at whether you need to appoint a nominated representative. Look at what temporary derogations might apply to transfers. Use the transition period to update privacy statements and internal policy documents to reflect transfers to the UK. Bear in mind, if you're an EU-based controller dealing with the UK, you have been getting warnings about this for the last 3 years from EU regulators. And the DPC has upped its guidance in the last 18 months. So by the end of the transition period, you will have had nearly 3 years to get ready. That puts you in a no excuses situation with the regulator. With the UK, the advice is pretty much the same, just reverse it. Understand what standard contractual clauses you need to put in place. Understand if you need to appoint an EU nominated representative. Look at what derogations might apply in the cases where you might be able to get things in place in time during the transition period. and make sure you update your privacy statements and internal documentation to reflect their transfers happening out of the UK to the EU. Other considerations, changes to website where transfers to the UK might be happening. Again, if it's a shopping cart type scenario, data has been transferred to the UK, you might want to consider making changes there in terms of your text that's been displayed to people. How you deal with partners who can't answer questions or who won't engage. What is the implication of turning them off? And how can you get them to delete data that they already have that you've provided to them? And how will you do rights of audit? How you ensure that the things you've contracted to do are actually being done in the third country. So if you're in the UK and you're dealing with an Irish supplier, how will you audit them? Where are your boots on the ground? If you're in Ireland or another EU member state and you're dealing with a supplier in the UK, how will you implement your audit effectively? And if you're using ad hoc contractual clauses where you're putting in place your own things, for example, for a processor to processor relationship, have they been approved by a supervisory authority? If they haven't been run past a supervisory authority, they aren't really covered as a basis for transfer. Our experience, we did a supplier review. We looked at what third parties we had. We asked what information they could give us about their Brexit preparation. We tried to find, could we get them to sign model clauses? We then looked for alternative solutions, and we queried data transfers for any purposes we had, for example, accounts or insurance. We replaced our HR platform with an Irish-based provider. We replaced our account software provider with an Irish-based provider. We raised queries with our accountants around transfers to their UK parents, and again, that's an ongoing process. And also, we cancelled subscriptions with UK-based services that we weren't using regularly, standardised on EU-based alternatives. We've been doing that. We put this in place over an 18-month period. We've updated our ROPA, we've updated our data protection policy, we've updated our data protection notice, we've updated our procurement policies, and we have selected a third party to act as our nominated representative in the UK should that prove necessary. So we have all these things in place ready to go. Conclusion. UK is now a third country. They're unlikely to have an adequacy decision for a number of years. Transfers will be unlawful after the transition period unless we've got things in place or unless adequacy has been addressed. Ad hoc provisions can only be used for occasional processing. Binding corporate rules can be considered. Model clauses are the quickest band-aid solution but are subject to challenge. And we need to consider what we're doing as organizations in terms of our contractual basis, our communication to data subjects about data that is transferring backwards and forth, and also looking at alternatives. Where we are now is here. We have a transition period, and in that transition period, there is 11 months to prepare. Castlebridge offers a range of services for organizations looking to assess where they are from a data protection perspective in preparation for Brexit, and details are available on the website, castlebridge.ie/Brexit. Okay, thank you very much for your attention. Thank you very much for your time, and in particular thanks to those of you from other consultancies who've come on the call, come on the webinar today. Appreciate you joining in. An addendum to the webinar. While we were recording the webinar, Boris Johnson was presenting a speech and a statement in relation to the plans of the UK government post-withdrawal agreement and during the transition period. I've selected some of the points from this speech just to illustrate the current position of the British government with respect to data protection adequacy post-Brexit. Firstly, the British government is going to work hard to achieve a balanced agreement in the interests of both sides, reflecting a wide range of shared interests. This sounds very good. However, Boris Johnson then went on to say that it cannot therefore include any regulatory alignment, any jurisdiction for the CJEU, or any supranational control in any area. This poses a problem because what we're beginning to see is the introduction of, in fact, what you're seeing here explicitly is a statement that the UK government is going to pursue a policy of regulatory divergence as part of the either the negotiation of the final future relationship, post-transition agreement, or post-transition period, or that once the transition has occurred, there will be regulatory divergence after that event, because they are disavowing regulatory alignment. Boris Johnson's speech concluded with a statement that there were certain areas where agreement is self-evidently in the interest of both sides, and where early progress is a test of the constructive nature of the negotiating process. And again, this sounds very, very positive and amenable. However, when we come to the final sentence in this paragraph, the UK sees the EU's assessment process on financial services equivalence and data adequacy as technical and confirmatory of the reality that the UK will be operating exactly the same regulatory frameworks in the EU at the point of exit, and that the UK intends to approach its own technical assessment processes in this spirit. This is a warning. We are facing potential regulatory divergence, inevitable, given the disavowing of regulatory alignment in the Prime Minister's statement. And secondly, they're approaching adequacy assessment as a tick box exercise, a technical tick box exercise on the basis that there is already regulatory alignment. What the Prime Minister's statement here says in the opening paragraphs is that there will be no regulatory alignment, but it concludes by saying, on the basis of the existing regulatory alignment, we expect all these other things to resolve themselves. On that basis, I think we need to be preparing for a situation where there will be no clearly defined adequacy agreement by the 31st of December 2020, and organizations need to start planning now for their prudent roadmap for data protection management and cross-border data transfers into the UK or out of the UK post-December